Good afternoon, members of the court. My name is Kevin Kelly, and I will be representing counsel on behalf of Nightingale Limited, who are the respondent to the arbitration proceedings. Opposing counsel for the claimant has made an unconscionable lodgment for the request of security of cost to the tribunal on this arbitration. We therefore take this opportunity to address the opposing counsel's flawed request for security of costs. I will review the grounds on which this request has been based and detailing why nothing herein and pursuant to the governing unisitual rules warrant an award for security of costs being placed against my client. I will address and make reference to the following claims by the opposing counsel against my client. 1. That my client will not comply with an adverse award and that enforcement of an award would be impossible given that Guyana is located in a remote location. 2. Media reports in relation to third-party funding. And 3. Reserves of cash and equivalents. However, I would like to firstly point out that the tribunal should reject opposing counsel's request for security of costs outright due to the request being made more than 1 month after the statement of defence was issued. According to the Chartered Institute of Arbitrators guidelines, which were published in 2015, application for security of costs should be made promptly. That is, as soon as the risk or facts giving rise to the application are known or have ought to be known. The opposing party would have been aware of my client's current financial situation long before making this request, and would have had visibility of my client's 2015 financial statement long before making the request. Therefore, the tribunal should reject Massive's claims based on the following statement issued from the Chartered Institute of Arbitrators. If the application is made after significant expense has been incurred, they may consider that this unfairly disadvantages the other party and refuse application unless there is a good reason for the delay. I do not believe that opposing counsel has any good reason for the delay, and I will refute each of the claims made by opposing counsel in support of their security of costs application. In regard to the opposing counsel stating that my client will not comply with an adverse award, I dismiss this entirely based on the fact that Guyana is a signatory to the New York Convention 1958. The New York Convention is one of the key instruments in international arbitration. The New York Convention applies to the recognition and enforcement of foreign arbitral awards and the referral by a court to arbitration. I would firstly like to state that the opposing party have their registered offices in Glasgow. My client has their registered office in Guyana. The project location is Xanadu, and the place of the seat of the arbitration is in England. Given that the Lex Arbitrae is the English Arbitration Act 1996, sections 100 to 103 of the Act provide for enforcement of an award under the New York Convention 1958. And furthermore, an arbitral award will be made pursuant to an arbitration agreement in the territory of a state which is party to the New York Convention 1958. As Scotland, England, Guyana and Xanadu are all signatories to the New York Convention, then any arbitral award issued by the seat, which is England, is enforced as under Section 101 of the Arbitration Act 1996. Therefore, my opposing party's claim that enforcement of the award would be impossible given that Guyana is located in a remote location is unfounded and irrelevant, as an international arbitral award would have to be honoured. The only grounds under which a court can, but is not obliged to, refuse enforcement are limited to those set out clearly in two articles of the New York Convention, both of which do not apply to this arbitration. Opposing party counsel also make reference to media reports that my client tried and failed to request third-party funding to fund this arbitration. It should be firstly noted regarding this issue that media reports are hearsay evidence and thus cannot be relied upon in court. Secondly, as stated by Patricia Sokovich, who is an associate editor for Badich and Partners law firm, third-party funding arrangements in and of itself is not sufficient indication that the claimant is impecunious, and therefore the mere existence of a third-party agreement is not sufficient reason for a tribunal to order security of costs. Furthermore, in a report written by Stavros Brikalaevkis entitled "The Impact of Third-Party Funding on Allocation for Costs and Security for Cost Application," he stated that anecdotal evidence suggests that at least 40% of current arbitration claims have either secured or explored funding from third-party funders, which would suggest that every party has a right to explore this option, and in the same report it is stated that, as with commercial litigation, third-party funding in arbitration is generally accepted and increasing. The IBA Guidelines on Conflicts, published in 2014, and the ICC Guidance Note, published in July 2016, advise arbitrators to disclose potential conflicts with third-party funders. However, this is only triggered if a claimant voluntarily discloses its funding arrangements, and the fact that media reports suggest that Nightingale did not actually receive third-party funding means that the tribunal need not consider this as a factor in their decision-making process. The mere mention of media reports by the opposing counsel seems somewhat tactical and unprofessional in support of their claim against my client. Finally, my client has shown that they have $5 million worth of assets available in order to satisfy an adverse award. In the case of Azos Shipping v. Baltic Shipping, the judge stated that if there are assets available for satisfaction of an order, there would be no requirement for security of costs. Therefore, as my client has proved this, the tribunal need not consider opposing counsel's request for security of costs. In conclusion, security of costs should only be granted in exceptional circumstances. I would urge the tribunal to reject this claim, as arbitral tribunals seem generally reluctant to grant claimants' requests for security of costs and issue orders with extreme caution and only in exceptional circumstances. According to P.A. Kara and M. Dasick in the article "Security of Costs in International Arbitration, Why, When and What If?", power to award security of costs should only be exercised in extreme circumstances. For example, where abuse or serious misconduct has been evidenced, as was shown in the case of Commercial Group and San Sebastian Coal Mines v. Republic of El Salvador. Therefore, the opposing counsel would need to prove these exceptional circumstances for award of security of costs, which I have shown they have not, based on the factors discussed in this presentation. Thank you.